Imagine that someone just handed you a will. Maybe it was in a drawer, maybe the attorney mailed it to you, maybe you just found it as you were going through your parents' things. And now someone is asking you whether you need to probate this will, and you're thinking, well, what does that even mean? I'm Dia Stana with Southern Estate Lawyers, and in the next few minutes, I will walk you through what exactly probating a will in Alabama means. So let's start with the basic question. To probate a will means to file it with the probate court, have the court declare it legally valid, and then go through a supervised court process of settling the deceased person's estate. The word probate actually comes from a Latin word which means to prove. And that's exactly what you're doing. You're proving to the court that this will is genuine, that it meets Alabama's legal requirements, and the person listed as executor has the authority to act. Probate serves several purposes. It creates an official public record. It gives creditors a formal window to file claims against the estate, and it protects the executor from personal liability when the process is followed correctly. In Alabama, probate happens in the county where the deceased person was a resident of. So, a question that we get often is whether every will has to go through probate. The short answer is no. Whether probate is required depends on how the deceased person's assets were held, not so much on whether they actually had a will. Assets that typically pass outside of probate are assets that are jointly owned with right of survivorship. Bank accounts or other financial accounts that have a payable on death beneficiary listed. Life insurance or retirement accounts that also list payable on death beneficiaries with alternates. And assets that are held in properly funded revocable living trusts. If the deceased person owned assets solely in their own names at the time of death without any payable on death beneficiaries listed, likely that person's will have to go through probate. Alabama also has a simplified process for smaller estates. As of May 2026, if the total probate estate is worth $47,000 or less, certain heirs may be able to collect those assets through a process called a small estate affidavit, and this occurs without having to go through the full probate proceeding. That threshold is subject to change almost every year, so verify current law when you're dealing with this. For estates that do require probate, here's what the process looks like in Alabama. There are 8 steps. Step 1 is to file the will with the probate court. You can take the original will to the probate court in the county where the person that died was last resident of. Alabama generally requires the original will. You file it along with a petition asking the probate court to admit the will to probate and appoint an executor named in the will. Step 2 is where the court admits the will. The probate judge reviews the will to make sure it meets Alabama's requirements. There's typically also a hearing. A valid will in Alabama has to be in writing. It has to be signed by the testator, and it has to be witnessed by 2 competent witnesses. If the will is self-proving, which means it was signed by the testator in the presence of witnesses, also in the presence of a notary public, and all of the heirs consent and waive their right to a hearing, the probate court judge is going to admit that will into probate. In the event that all heirs do not consent to this will being admitted into probate, the probate judge will set a hearing in order to adjudicate whether or not to admit this will into probate. Step 3 is where the executor is appointed. Typically, this happens at the same time as admitting the will into probate. The court then issues letters called letters testamentary. These are the important documents that give the executor the legal authority to act on behalf of the estate. Banks, title companies, and other government agencies will ask to see this specific document. When you have to present this document to these agencies, make sure you have the original. Copies will not do. Step 4 is to provide notice to creditors. Alabama law requires that notice be given to all known creditors. Notice also has to be published in a newspaper for 3 consecutive weeks to make sure that any unknown creditors have proper notice. This allows anyone that may have a claim or who wants to contest a will a chance to come forward. Step 5 is an inventory of the estate. The executor identifies and values all the probate assets. real estate, bank accounts, investments, personal property, and vehicles. Unless waived in the testator's will, a formal inventory is typically filed in the court. Step 6 is to pay the debts, taxes, and all the expenses. Before any distributions can be made to a beneficiary, the estate has to pay the valid debts, creditor claims, or any taxes owed. Alabama law has a specific priority order to pay the debts of creditors. This sixth step matters a lot, so pay attention. In Alabama, the creditors are allowed 6 months to file their claims. One of the common mistakes an executor makes is distributing funds to beneficiaries before the 6 month period has elapsed and before they have paid all valid debts. You don't want an executor to be in a position where there is not enough funds left after distributing to heirs to actually pay these debts. Steps 7 and 8 are to distribute the remaining assets of the estate to the beneficiaries and to close the estate. Once debts are settled, the assets go to the beneficiaries pursuant to the terms of the will. An executor will obtain signed consents from all the beneficiaries and then proceed to closing the estate. And once the court approves this, the executor's job is done. So, how long does probate take in Alabama? For a simple estate, you're looking at between 6 months to maybe a year from the date of opening the estate. So, what stretches this timeline? A contested will is the biggest one. Real estate that needs to be sold, business interests that need winding down, or a significant creditor claim can also extend the process. Most people don't realize that the county that you're in makes a huge difference. Different probate courts in Alabama have different processes and different timelines, and there is no way to speed past the required by law notice periods. But working with a local probate attorney can prevent delays caused by missed deadlines or filing errors. And those delays, they add up fast. So, how much does probate cost in Alabama? The costs of probate vary depending on the size and the complexity of the estate. There are 4 main categories. So, the first is the court filing fees, the second is publication costs, third is court costs pertaining to certified copies of letters testamentary, and last is attorney fees or accounting fees. For most estates, the attorney fees is a small fraction of what the total estate value would be, and they're typically offset by doing it on your own. So, what if the will is contested? If someone challenges the will, the probate process stops until that challenge is resolved. In Alabama, the most common grounds are lack of testamentary capacity, which means that the person who signed the will did not know what they were doing. Undue influence, which means that someone manipulated or pressured the person to sign the will and it does not reflect their true wishes. And improper execution, which just means that the will does not meet the formalities required by Alabama law. The deadline to contest a will in Alabama is typically 6 months from the date that it was admitted into probate. If something does not look right to you in a will, it's definitely worth a free consultation with an estate litigation attorney. And if you're an executor and the will has been challenged, legal representation for you is not optional. In Alabama, an executor cannot defend themselves on their own. If you're holding a loved one's will right now, here are 7 things that matter most. Number 1 is to secure the original will. Keep it in your possession. Make copies, but secure the original. Number 2, do not transfer, sell, or give away any of the estate assets, not yet. Without court authority, those actions can result in serious consequences. Number 3 is to recognize the county where the deceased was last resident of, and that is where you file for probate. It's the county where the person was domiciled, not just where he or she owned real property. Number 4 is to start a rough list of all the assets and the debts. It doesn't have to be perfect. Create a basic picture which will help your attorney to help you best. Number 5 is to reach out to a probate attorney before you take any steps. At Southern Estate Lawyers, we offer free consultations, so please don't hesitate. Just ask your questions. Number 6 is when the probate court issues letters testamentary, make sure to ask for more certified copies. You will need them. And number 7, if possible, document everything from day one. Receipts, decisions, conversations, just keep a record. Most families that call us for probating a will, They didn't expect to do it so soon. They found a will and they don't know what to do with it. They're already carrying a lot, and now there's legal paperwork and deadlines. You don't have to know how to do all of this before you give us a call. Helping you with all of this is exactly what we're here for. Southern Estate Lawyers is here to help Alabama families from day one of when to file for probate to the final distribution to beneficiaries. Our consultations are free. If you're ready to talk through your situation, click the link below or just give us a call directly. We look forward to working for you.